Morning, everybody. Hopefully this is as exciting as science is. Man, I haven't been that excited about science probably ever, but I like numbers, so I'm glad you found, what's you're passionate about. That's awesome. Um, this afternoon I've got Tara Kuchar. She's originally from Granite City. She went to undergrad at Butler and then moved back to the area after that and went to law school at St. Louis University and graduated in 2008. She's currently a partner at Hepler Broom here in Edwardsville and focuses on employment and labor law and a few other legal areas. I've asked her to speak on the Illinois Paid Leave Act. When our HR department implemented this last fall, it was pretty eye-opening for me. All I really learned was that I needed to tell my clients to go speak to an attorney. But I know that there's a lot of business owners in here or people that work with business owners, whether that's bankers or insurance agents. So hopefully everybody learns a little something. For anyone that's an attorney and already knows all this, sorry. But so I'll let Tara take the floor.
Fine. My first test will be.
Let's go. Put your PowerPoint up.
Yeah.
Sorry. Station.
Yes. Well, that was that was tough to follow. So maybe at least I've started with a pretty picture. So maybe that'll be a step in the right direction. First, thank you so much for letting me come to speak to you today. I will keep this as brief as I can. I also can talk very quick. So if we need to fly through, I can. But today what I'm going to talk to you about is the Paid Leave for All Workers Act. I call it a primer because my goal today is sort of to just give you a high level overview of what the act actually requires. You might be asking yourself, why in the world would I pick a tidal wave as the picture for a Paid Leave for All Act presentation on the law? And the reasons for that are, first and foremost, I think it's a sea change in Illinois law. It's a clear pronouncement from the General Assembly that working Illinoisans are entitled to a certain amount of paid leave to use however they want. I think as we'll see a little bit later, when we look at some of the details, you'll see how this is different than what we've ever seen before. It also is, a beach. When we think of paid time off, I think often we think of vacations. But the more serious reason really is that the Paid Leave for All Workers Act does carry serious penalties for noncompliance. And I also feel like the tidal wave is a perfect example. If anyone's been to the beach, and you're out there frolicking, you're having a great time, and then you get hit by that wave that you didn't quite see coming, or it turned out to be bigger than you expected, and next thing you know, you're tumbling in the water, you're a little disoriented, and it feels very uncomfortable. I would suggest to you that non-compliance with things like the Paid Leave for All Workers Act might leave people feeling similarly disoriented and a little bit unsettled. So hopefully today we can change some of that. Okay, so let me give you a quick status update on the law. It became effective on January 1st. So if you're looking at the calendar, you realize we're 18 days in. There had been some effort to push back compliance to July in the veto session, but those efforts were unsuccessful. So January 1 was the start date. There's also proposed regulations that were published last fall. This has an asterisk because they're not final yet, which means that while they can be informative and instructive, and I may refer to them, they do not yet have the full force and effect of law. So that's also sort of what makes the Paid Leave Act a little bit confusing, because we have the statute that everybody has to comply with, and we have regulations that are not yet final, and everyone's trying to figure out sort of their way in the dark of compliance to make sure that they're doing what they need to be doing, even though maybe some of those details aren't quite so clear. And then the last resource I would direct you to also is the Illinois Department of Labor. They have a number of frequently asked questions. Again, they are not binding. They're not legal advice. If you go to that website, you'll see a million disclaimers that tell you that. But I would point that to you or bring that to your attention, because if you have a question and you're not quite sure, it is a resource that's there. They also have a number of webinars on the Paid Leave Act that they've done periodically. So that's another resource. It's just important to know the only solid legal requirements right now, though, are the act itself. So I always like to start with the why when something is new. I think it's important to understand why a change was made. And I also think in the context of business owners who are thinking about the correct path forward or changes that have to be made, it's sort of important to understand what they were trying to achieve so that you can make decisions consistent with that. And as I said earlier, the point of the act is to give all Illinois workers paid leave and economic security. One of the hallmarks of this act really is that workers can use this paid time off for any reason at all. It's not just vacation, it's not sick leave. As we'll talk later, you can't even make people tell you why they're using it. It's just something that's available to them. It's also in the statute itself, they talk about the purpose of the act, and really that really is just to make sure that people have this time for whatever reason they want. Maybe it's mental health, maybe it's to take care of family things, but it's very clear that they want people to have paid time off to handle things as they see fit. The other thing I would call your attention to, whenever you have these acts that get enacted and people put policies, and if you ever end up in a lawsuit, and you're ever asking a court to interpret whether or not what you did complied, and if the statute's ambiguous, they're always gonna go back to like, why did the General Assembly do this? What was their intentions? But they're also gonna look to things like this third point here, which is the act is to be liberally construed in favor of providing workers the greatest amount of paid time off from work and employment security. So if there's ever an ambiguity, that's what the courts are gonna look at. So, I mean, a tie is probably going to go to the employee on the issue if I had to guess. So just be careful of that. So who does the Paid Leave Act cover? Employers who employ one or more people. There are a few statutory exceptions. Park districts that are founded under the Park District Code, school districts that are, governed by the school district code. But otherwise, if you're an employer in Illinois and you have one employee, you have to comply with the Paid Leave Act. Unlike other civil rights or different employee type laws, or maybe you have to have 50 employees or 15, that is not the case here. And then the question is, which employees does it cover? All of them. This is, I think, where the sea change really comes into play. Many employers offer full-time people paid time off. Like, that's not especially controversial. Part-time employees, some employers may have. Now you have to. Now they have to be able to earn paid time off, and that is true of seasonal employees, any employee. They do not distinguish between classes of employees under the statute. So again, this is one of those areas that I think can kind of catch people unaware, and it's important to know that this is sort of the new landscape. One of the number one questions I would get asked is, well, what if I have a paid leave policy? Do I have to make any changes? This is exactly what the statute says. It says that an employer who provides any type of paid leave policy that satisfies the minimum amount of leave required by the act is not required to modify the policy if the policy offers the option, employees the option at their discretion to take paid leave for any reason. So the regulations that have come out have sort of changed this a little bit. Again, they're not final, but they've now suggested that, well, I guess if you had a policy that did all this before January 1st, that's not found in the statute. And so this is an area of confusion. What I have told people before January 1 and what I would tell people now is that if you're wondering if you need to comply, if your existing policy does comply, just read and review your own policies, your handbooks. Take a really close look to see if you are giving leave to everybody, what does that look like? And then you can make an informed choice about whether or not you do need to consult an attorney or make changes. Because I think it's a little unclear now that we're past January 1, you want to make sure that you cover all of those different aspects. So the Paid Leave Act basics, there's no reason required. You cannot require your employees to tell you why they're using Paid Leave Act. Can't ask for them to give you documentation and certification. That's a little bit different. If you have bereavement policies or different FMLA or medical leave policies, often you're allowed to ask people to either give you an authorization so you can get medical records. You can ask them for certain pieces of information to support their use of that leave, but under the Paid Leave Act, that is not allowed. You can have notice requirements. So if you want your employees to provide advance notice, you can have that, but it can be no more than 7 days. And you can also have a policy that states if the leave is for an unforeseeable purpose, you can have a process that they can use to notify you. And this is also kind of interesting because a lot of times we think of paid leave as you have to have advance notice, and they're very clear under the act. It doesn't have to be leave that has an advance notice. People could just decide, you know, I was in a car accident on my way to work about 7 years ago. I did not finish my day. I did not even show up that day. I was fine. My car was not. But if an employee were to call into that situation, they could utilize leave under that. So you can have those notice requirements if you have to use it after the fact, but you have to put it in writing. Your employees have to know who do they contact, how do they contact them. And if you're ever going to make changes, you have to give sufficient notice. So that is one issue. Under the proposed regulations also, we will talk about this in a second. You can deny paid leave in certain circumstances, but you can't deny paid leave simply because they didn't comply with advance notice. So that's in the regulations. That's not, you know, again, not full force and effective law, but that's sort of where they're headed with that. You can limit the time. You can put minimum increments of 2 hours. Of course, employers can always be more generous. That's always allowed under the law. You can always do more than the least, but that is sort of where they're at right now. And you can never ask an employee to waive their rights to paid leave under the Paid Leave Act. This is different if you have a workplace where you have collective bargaining. That's different. But typically speaking, in a normal employee, non-collective bargaining environment, you cannot ask people to waive their rights under the Paid Leave Act. It's considered void, meaning the agreement never happened. And that is just never a place you want to find yourself, is being party to an agreement that is void and has no effective law. So what are the options? The Paid Leave Act offers a few. You can front load the time, meaning and have an adopt a use it or lose it policy. Then you don't have to allow people to carry it over. You can also do an accrual method. In that case, the leave has to carry over. But you don't ever have to allow employees to use more than 40 hours if they accrue it. 40 hours is the absolute minimum amount of time. Employees in Illinois, under the Paid Leave Act, you're guaranteed 40 hours of paid leave or a pro rata amount. Under the act, you cannot add Paid Leave Act leave to existing vacation PTO banks unless your policies have been changed to explicitly state you're doing so. The number one thing to be aware of here is if you add it to existing vacation and time off banks and that employee leaves, that leave has to be paid out as you would as part of your normal separation payments as required by the various wage payment laws. If you don't add it to a bank and you have a separate Paid Leave Act policy and people leave, then you do not have to pay out that time. So that's kind of an interesting difference that you want to be aware of if you find yourself in a situation of either creating a new policy or changing the policy that you currently have. So as I mentioned, employees are to accrue 1 hour of paid leave for every 40 hours worked. That is the math that the Department of Labor is looking at. You can have, 0.025, or you have different ways. Companies do things differently. But you want to make sure that if the Department of Labor ever comes knocking on your door, that you are able to show that people are accruing leave that's consistent with this formula. For exempt employees, they're deemed to work 40 hours in each work week unless their regular work week is less than 40, then that lower amount will govern. And the accrual for employees begins on January 1st. This often comes up when people had existing employees that didn't, if you have part-time employees who never had any paid leave. Now we get to January 1, they do. One of the questions that comes up is, well, where do I start the accrual? You started at January 1. That's the date the act became effective. And then you can limit employees. You can make people wait 90 days to use it. So on the 91st day, they have to be able to use it. Interestingly, there's some wonkiness and a little bit of the proposed regs, which is with regard to carryover, they will say that you have to show that employees are accruing leave, even though they can't use it for 90 days. So for new people, it's kind of a wonky part that we'll see if that gets fleshed out in the final rules, but that's one of the oddities that exists now. When you have employees that transfer or reinstated, the act governs that as well. Employees who transfer within your same company, if they go to someplace, different work location, different department, that accrued paid leave transfers with them and they can use it. Employees who separate but are rehired within 12 months, they get their prior accrued but unused leave reinstated. And there is some suggestion that if you pay that out, you would not have to reinstate it, because that would be sort of a double penalty. But that is where the act stands in terms of transfers and reinstatements. And I talked about this earlier, of whether or not you can deny a request to leave. I mean, I know depending on the industry that you're in, there are just certain times of year that you just really can't have everybody out. Or maybe it's a seasonal thing, or just you're a small enough shop that when people, like, if everyone just left, you'd be really left in a lurch, and what would you do? Under the proposed regulations and the frequently asked questions, the law so far is clear that there is a basis that you can use to deny leave to somebody, but it's typically going to be viewed through the lens of operational necessity. So, I mean, if you are a company that has 4 employees and 3 of them decide they want to leave, so the last person who asks, you have to say, sorry, I need you to show up. You want to be able to make sure that you've articulated that you can make those denials, and then have some objective business related reason for making those determinations if you're going to deny leave. And again, you have to provide notice. Employees need to know that that is what could happen. Paid Leave Act has pretty serious anti-retaliation non-interference. You are not allowed to get in the way of anyone who wants to use paid leave, who tries to support others who want to use paid leave, or even who just thinks that maybe you're not doing the right things under the paid leave and they take action. You cannot retaliate, and you also can't change scheduling in a way to avoid people from getting their paid leave. Not that anybody would do that, but it's important to know that it's also a statute. There's also substantial record keeping and retention requirements under the act. You have to keep it for 3 years. You have to make sure that you can show hours worked, leave accrued and taken, balances. And you have to give a lot of notice. You have to have the poster from the Department of Labor, have it in your handbooks. And there's even some suggestion in the regs that, like, the poster from the Department of Labor might also have to be somehow added into your handbooks. That's unclear. It seems a little bit at odds and a little bit overkill, but we'll see how that shakes out. But in short, same types of notice requirements, and you really want to make sure people are aware. And again, compliance is critical. Employees can file complaints with the Department of Labor. They can seek damages, including underpayments, compensatory damages, penalties of $500 to $1,000 for the violations. And then in addition, businesses can be hit with the civil money penalties out of the Department of Labor. And that's the quick primer on the Paid Leave for All Workers Act. I know that was fast. Are there any questions, or can I? Yes.
Can you go back to the accrual?
Okay.
Okay, and the banking of the carryover?
Mhm.
So help me understand that in terms of, okay, so you get 40 hours. So if they use 20